Board of Elections will hold a special meeting of the members of the board on Monday, July 14th, 2025 at 4:30 p.m. in the boardroom of the Mahoney County Board of Elections offices, 345 Oak Hill Avenue, Youngstown, Ohio, 44502. Would the director call the roll, please?
Vice Chairman Barger.
Here.
Chairman Beatrice.
Here.
Attorney Robinson.
Here.
Attorney Bayer.
Here.
Would the vice chair please lead us in the pledge of allegiance?
I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Could we please have a moment of silence for our nation and for those who were recently lost in a plane crash, including one of my fellow bar members. We will now proceed to the chairman's report. The chairman wants to read something. We are sworn to follow the directives of the Secretary of State, so I'm going to read what the purpose of today's hearing will be. When a Board of Elections conducts a hearing as part of an investigation or in resolving a protest, it is acting in a quasi-judicial capacity. Quasi-judicial means that the board's actions have a partly judicial character by possession of the right to hold hearings on and conduct investigations into disputed claims and alleged infractions of the rules and regulations, and to make decisions in the general manner of courts. In a sense, when the board conducts a hearing, it is acting as the judge and jury in a trial court. While acting in a court-like manner, boards must ensure due process rights are observed. Accordingly, a board must inform its legal counsel, the county prosecutor, to make sure that it is conducting the hearing appropriately. Not every complaint the board receives should result in a quasi-judicial hearing. For example, a protest that does not specify its legal grounds is invalid. Likewise, there are many statutory deadlines for board actions. Before preparing for the hearing, a board should ensure the hearing is appropriate and still within their ability to resolve. Again, the board should work with its legal counsel throughout the entire process. Boards are government bodies that must abide by state and federal constitutions. When acting in a quasi-judicial capacity, they are taking away or defending fundamental rights for Americans, like the right to vote or run for office. Due process rights ensure that boards do this fairly and deliberately. Before a board holds a meeting, it must notify the parties for the matter. Notice does not need to be fully fleshed out of all the processes and possibilities for the matter, but it must be sufficient for a person to determine what is being proposed and what they must do to protect their interests. For example, a protest hearing, the candidate must receive notice that 1, a qualified elector has asserted that the person cannot be a candidate, 2, the grounds for that assertion, and 3, the time and location for the hearing. The board must hold a hearing before taking final action in the hearing. The hearing must be granted a reasonable time and in a reasonable manner. The board, acting as a judge and jury, must be impartial. They must strive to ignore anything heard or recalled outside of the hearing and pay attention only to the evidence before them. They are entrusted to oversee elections honestly without bias. Board members are not exempt from ethic laws and may need to recuse themselves from hearing. Any person who participates in a hearing may be represented by an attorney. This includes a person accused of something, the person making the accusation, and witnesses. A person accused of something who will suffer a loss as a result of the hearing has the right to confront the person making the accusation. For a board, this generally means the person accused gets to question the person making the accusation. So those are the rules that we're going to follow. We have 2 matters before us. One is the reconsideration for Mary Janick for the city of Campbell in the 3rd Ward. Mary Janick, are you here?
I am.
You want to come forward, please? Now, so everyone knows, we are taking everything down by a court stenographer. In the human course of interaction, human beings use nonverbal cues to communicate in a lot of ways. That cannot happen here. Everything you say must be said audibly, because if reviewing court is reviewing this, it cannot take down shrugs of shoulders and quizzical looks. So everything must be audibleized. We will swear you in. We will let you state your case, and then we'll go from there. So, could you raise your right hand? You solemnly swear to tell the truth, the whole truth, and nothing but the truth. This you do, you answer before your God or under the penalty and pangs of perjury under the state of Ohio.
I do.
Okay, did you send the Board of Elections, it looks like an email on July 9th?
Yes, I do.
Okay, would you like to make your case as to why we should reconsider your petitions?
Yes. Thank you for this opportunity, ladies and gentlemen of the board and Director McCabe, as well as Deputy Director Washko. I appreciate this time that you're giving me to take a look at the information that's presented. If I might reiterate some of those ideas that are in the writing and reconsideration for this petition being accepted, it is that I followed what was given to me from the Board of Elections. When I picked up my envelope, it said clearly on the outside, petition form by Campbell City Charter. So I could tell them that my directions for filling out the petition were found in my city's charter. The petition itself asks for a place for my name, clearly my address, and then the office that I was seeking, which is city council member. Using the map that I was provided by my town for where the wards appear, I went to my friends and neighbors and gathered signatures according to the charter. The qualifications for the charter are delineated and defined solely by the address of the candidate. It says each member of council shall be qualified elector of the municipality and shall have resided therein or in a territory annexed thereto for a period of at least 2 years. I've owned my home for 28 in that town itself. And that as I was running for council, I was clear to each of the people that I asked for their signature and that I was going to be their representative and their city council member. It seemed that there was no confusion, if I might quote information from Director McCabe that was given to the news media, which stated that Mary Janick, who was running for 3rd Ward Council position, failed to put a number on my petitions. Nowhere within the city charter is there numbers referred to for our city council positions. In Article 6 of our city charter, it talks a little bit about the mayoral candidates or the candidates who are running for president of council, and then calls for members of council or councilmen. I filled out my petitions. I've gathered the petition signatures from my friends and neighbors within my neighborhood, and I've turned those in a timely fashion. I would ask that you would let the electors of Camel, who would only receive the ballots that would have my name on it, if they were part of my part of the city, within the area that is for my neighborhood. And so if you would reconsider, and then for the relief that I'm asking is that my name be placed on the ballot for that general election, which will happen in November.
Thank you. I have a question for the director. It seems to be a conflict between the Campbell City Charter and Ohio law. If the Campbell City Charter does not require that the ward be listed in the petition, then how can we require it?
I think in the past, and we've seen this where the charter remains silent, the revised code then takes precedent over that.
What, do we have anything, the county prosecutor's not here, right, even though you informed them of this?
We did inform them.
I'm having a problem with the fact that the city charter does not stipulate that the board member be listed in the petition. That's the people of Campbell have voted on that charter. And they have said, you know, just say you're running for council and that then the ward doesn't have to be listed. I don't know, I'm having trouble with the decision we made now that I see that that's not listed in the city charter's provision. I was wondering what else everyone else was feeling about that.
She should add notice of what the requirements were. She thought
She said that she picked up her petitions and the petition said, Chuck, what did you say it said on the outside?
It says, petition form by Campbell City Charter.
So, in other words, what she's,
Are the petition forms the same for all council members,
That's
like
correct.
in different cities and things? Like it's a form that the state uses, correct?
Correct, correct. I believe it's the
So-
same form on its face is that Youngstown uses who has more races.
Okay.
Yeah, but Youngstown in their charter specifically list, don't they, that in the petition, you gotta list which one you're running for?
I don't think they do. It's, what we've always relied on is that the revised code says it must list the office you're running for. And we've always taken that as a board. If you're running for the first ward of Youngstown, or the third ward, or fourth ward of Campbell, or Struthers, that has to be included. And again, this is the board's decision.
Is this a board's decision, or is this a fatal flaw? Because there's a difference.
We've always taken it in the past that that's a fatal flaw, but
This is the one, this is, yeah, but what,
yeah, but Struthers isn't a charter.
Right.
see, there's a difference between a corporate city and a charter city. So a charter city, the people vote on the charter. And so if the people voted saying, when you run, you don't have to stipulate the ward number you're in, I would think that that's what people voted on. That would be my position. I'm always for, the suffrage of the people, unless there's rules that prohibit it. I think she makes a pretty compelling argument here. She was given a packet by us. It said, look to the city charter. She looked to her city charter, and it says, directs nomination and election in Article 6, section, does not stipulate that the ward number be listed in the petition. That's what the city charter says. And it says, each member of the council shall be a qualified elector of the municipality and shall reside therein or in a territory annexed thereto for a period of 2 years immediately prior to the date of filing declaration of candidacy for such office.
Have you had a charter issue like this in the past, where the
We've
word
had-
is not
Yes.
specified?
Correct, the city of Youngstown, we've had it in the past numerous times.
Yeah, but doesn't the city charter say what one you're running for?
Is their charter different than Caitlin's charter?
Do we have someone here from the law department from Youngstown?
Yeah,
You do.
you go ahead, we have the answer for you if you want.
We do, in fact. Jason Small on behalf of the city of Youngstown. Do you have any questions?
Well, in your charter, when they get their petitions, do they have to delineate what council seat they're running for?
I'm not entirely sure. That is not a provision I was prepared to speak on tonight, this
Okay.
evening. I can get that answer for you very quickly tomorrow morning if you'd like.
No, we gotta make a decision today.
I believe that even if there's a conflict, that the charter will take precedent, and you're allowed to have a disparity between the law of the City of Ohio revised code as opposed to the charter.
And I would definitely defer to someone who's made a lot more judicial decisions than I have in my life, or ever will in my life. So, I would make a motion that we, go ahead, I'm sorry.
It says in Article 2, like the second to the last sentence, each councilman elected or appointed to represent a ward shall be a continuous resident of qualified elector of the ward he represents or territory. It does use the word ward in here, though, which would kind of change, you're running for council, but you're running for a specific ward.
But
You're
you're
gonna
running because of
represent a ward.
your address? You're running because of your address?
Well, I understand that all your signature is qualified,
But my address
but
was
your
also
title will be what when you're elected?
Camel City Council member.
Something ward, won't it be a ward, because you're not the whole council member?
Everything that I found within this says councilman over and over again, and it doesn't ever stipulate councilman of a particular ward. It just says councilman over and over again.
Does the board have any other questions, Denise?
Were you only provided with that packet in reference to the
Campbell City Charter, or were you also provided with the petition requirements under the Ohio Revised Code?
No, the packet itself had the petition papers in it, which clearly asks for my name, my address, and the office saw it, and then gives me an area for petitions underneath, and I had to use 2 of those forms. And inside, there was information that was on creating a commission or a committee. And there were a few pages on that was in the packet, and that was it. So the directions basically on the outside were petition form by Campbell City Charter.
But when your name is put on the ballot, it will specify which ward you're running, correct?
I believe that the people who are in particular areas will receive only those sections. So that people from Wilson Avenue, let's say, which isn't anywhere near my neighborhood, would not see my name appear on the ballot. Or people from another part of town that's a little further to the north, which is called Pin Oaks, would not receive my name on their ballot.
And I'm assuming that, Tom, every signature she got was from the 3rd Ward.
I believe it would,
Yeah.
yes.
She had the signatures required.
Well,
Yeah, she didn't meet the central requirements. When to answer your question, Sandy, yeah, the ballot will say 3rd Ward, 1st Ward, 2nd Ward, 3rd Ward, that's how Campbell broken into.
but will the petition have, what, people in the 3rd Ward would not be getting a 4th Ward petition? Would not be getting a ballot. They would
Correct.
only be getting a 3rd Ward.
That's correct.
That changes my mind even more. Because they can't, it's not like they would have a choice to vote on everything else. They could only vote in the 3rd Ward.
That is correct.
Do you have any more questions?
I do not. So when we accepted her petition, and we, out of the Board of Elections allocate, when we received the board review, that this was under Ward 3, based on her address on the petition?
No, it was that she didn't identify the ward on her petition.
No, it's on
No,
her.
I mean, we received this, and we knew that she was running for Ward 3, even though it wasn't on her petition.
Correct.
What was that based on, her
I believe
address?
it's a signature book, the assignment book, the receipt book, which I can grab. But
Okay.
we also knew her address, and we knew that we lived in the 3rd Ward, so we were checking those signatures based on the 3rd Ward.
Okay.
In the past, we would have caught this because we used to have pre-checks, and we're not allowed to pre-check petitions anymore in any sense. And the board passed that motion 2
Right.
years ago, 3 years ago.
Mhm.
So we used to be able to, when that candidate came into the county, we'd say, you're missing this. But under the Secretary of State directive and the board's directive, that we do not pre-check anymore.
Does the board have any other questions?
Mr.
I
Chairman,
think Judge Diabolito would like to be
if you want a citation, it states Pennington versus Bivens, 2021. And the quote from that case is, in the event of a conflict with state law, the charter prevails on matters of local substance.
That's why I said he's made a lot more decisions than me. Go ahead.
If I may add, in matters of qualification, and you may hear from us later, the municipal law takes precedent over state law, but the general laws of Ohio with regard to elections apply in the absence of any local state rule or ordinance, local municipal rule or ordinance.
See, I know that there's 2 types of cities in Ohio. There's a charter city and a corporate city. Campbell is a charter city, so the people vote on these provisions. And so the people have voted directly on this, saying, this is what we are requiring. And I think what the judge is saying and what that case is saying is, if the charter is in conflict with the state law, the charter would take precedent. And she only had 3rd Ward signatures, and, sometimes you get a ballot and it'll have a lot of things on it, but she can only vote, people are only getting her name and whoever her opponent would be. Is there any other questions from the board? I'd make a motion to reallow Mary Janick to appear on the ballot based on her letter and based on a reconsideration.
Second.
There's a motion made by the chairman and a second made by the vice chairman. Is there any comments, questions, or concerns more than we've already had? Hearing none, would the director call the roll,
Vice
please?
Chairman Barger.
Yes.
Attorney Beatrice.
Yes,
Attorney Robinson.
Yes.
Attorney Becker.
Yes.
congratulations.
Thank you very much for your consideration.
All right, the next hearing is a hearing for John White, candidacy for the city of Youngstown mayor. There was a, was there a petition to disallow it? How did this come about to us?
It came up because this was a previous issue 4 years ago, the residency requirement. We asked for an opinion from the Youngstown Law Department, they gave us an opinion. And then John White's attorneys also submitted a opinion to this board.
So
Right,
we haven't made any motions at all whether to put him on or not put him
So that's correct.
that's right. And so this is the hearing. So what we're gonna do is we're just gonna we'll let the city go first, and we'll let Mr. Myers go, and then you guys just keep going back and forth until you think you beat that horse to death. And then we'll make a decision. How's that? That way, everyone has had plenty of opportunity to be heard. We've given everyone their due process, and every legal argument you want to make, you can make in case there's a review of this, so we can flush it all out for any reviewing court, should there be a reviewing court. So I'll let the city go first.
I'll begin and Mr. Small can handle things after that.
Would you introduce yourself for the
Yeah,
record?
Attorney Lou Diapolito, Deputy Law Director, City of Youngstown.
And I'll just say for the record, when you are an attorney at law, you are given the benefit of not having to be sworn in before a tribunal, because as an officer of the court, you are under an ethical obligation to tell the truth in a quasi judicial proceeding. So, go ahead and Judge Mr. Depley.
I believe that this is more, not as complicated as one may think. There are requirements to run for office in Youngstown's a charter city. And we placed upon candidates who wish to run conditions. And in this particular case, to run for mayor, you have to be both a resident and be an elector for 5 years. We did not look into the residency requirement. That's something for the board to determine if they wish. The matter of being an elector is not defined by our charter. State law says an elector is someone who is of a certain age and basically a resident for 30 days before an election. The city of Youngstown has the right and chose to add to that other conditions, and not only be an elector, which means that Mr. White can vote in the November election, but he does not qualify until February after the expiration of 5 years in order to be a candidate for mayor. The word "and," of course, means both, to be both a resident and an elector. If it were to be construed as Mr. White wishes, it would have said, I would suspect, a resident for 5 years and an elector. But in this case, both requirements are necessary. He fails to meet those. We did not look at any other matters of any other conditions that may be required by this board. I think that kind of summarizes our position.
Okay. Anything else?
I think that to begin with.
All right, Mr. Myers?
Yes, good afternoon, members of the board. We have two basic arguments. One revolves around the issue of this word "and" in the charter. Whether the charter means he's got to be a resident for 5 years and an elector for 5 years, or whether, as the charter says, he has to be an elector and a resident for 5 years. So in other words, we dispute what Mr. Dipolito and the city say is the meaning of the charter in terms of whether he's got to be both a resident for 5 years and an elector for 5 years. But let's set that aside for a second, because I think that this decision is easier, as Mr. DiPolito said, than it looks. Because my second argument is that even if he's got to be both an elector for 5 years and a resident for 5 years, he meets that condition, because as the city law director in her letter said, there is no definition of an elector in the charter itself. But there's a definition of an elector both in the state constitution and in state statute and in case law that's been interpreted by the Ohio Supreme Court. An elector is a person having the qualifications provided by law to be entitled to vote. It is not equivalent to being registered to vote. You don't have to be registered to vote to be considered an elector. The Ohio Constitution, Section 1, Article 5 says, and I cited this in my letter, every citizen of the United States, Mr. White checks off that box, of the age of 18 years, he checks off that box, who has been a resident of the state, county, township, or ward such time as may be provided by law, the law being the charter, but the charter is silent as to that, and has been registered to vote for 30 days. He only has to be registered to vote for 30 days, has the qualifications of an elector, and is entitled to vote at all elections. Ohio Revised Code 3503.01A has similar language. Every citizen of the United States who is of the age of 18, check, check, years or over, and who has been a resident of the state 30 days, next preceding the election at which he offers to vote, is a resident of the county and precinct at which he offers to vote, check, check, and has been registered to vote for 30 days, has the qualifications of an elector. There's no dispute that Mr. White meets all those criteria and has been registered to vote for about 4.5 years. It's not the 5 years that the city wants to graft on to the silence of the charter language to be an elector. It's 30 days. And I quote in my letter also the Ohio Supreme Court, State Ex Rel. Calvin versus Bruner, 120 Ohio State 3rd, 110. An otherwise qualified citizen must be registered to vote for 30 days as of the election in which the citizen offers to vote in order to be a qualified elector. So even if you set aside this difference between 5 years being an elector or currently being an elector, Mr. White qualifies as an elector despite when he registered to vote. The registration to vote is not part of the definition of being an elector. In other words, one can be an elector without being registered to vote, and that's where Mr. White makes up this 6 months difference that the city wants to graft onto it between 4.5 years and 5 years. He only has to be an elector for 30 days. And the further point that I make, and as Mr. Beatrice has said over and over again in this round of challenges, and I suspect in challenges in the past, is that this should be suffrage of the people. The courts tell us that the statutes and the ordinances and the charter provisions should be liberally construed in favor of allowing people on the ballot and let the people decide. As the Ohio Supreme Court has said in State Ex Rel. Walsh versus Board of Elections, 65 Ohio State 3rd, 197, words limiting the right of a person to hold office are to be given a liberal construction in favor of those seeking to hold office, in order that the public may have the benefit of choice from all of those who are in fact and in law qualified. So the city's position is that because of this construction of the word "and," he should be off the ballot. Our construction is that the "and" means 5 years residence and 5 years elector. But even if you agree with the city on the construction of the word "and," he still qualifies because an elector is not the same as being registered to vote. He's been an elector for more than 30 days, and he should be on the ballot.
Mr. Myers,
Listen.
this is a charter city, correct?
Correct.
And so the residents of the city of Youngstown voted on this provision, right?
Correct.
And I'm just asking you, John Q. Public, how do you think John Q. Public interprets shall be an elector and a resident 5 years preceding? It seems to me that that's saying you must be voting for 5 years and be a resident here for 5 years. That seems to be the plain reading of what the people voted on in this charter provision.
Well,
Can I respond?
Well, yeah, I'll let you respond, but I want to ask him first. Go ahead.
I disagree with that, because I think that if they'd have meant an elector for 5 years and a resident for 5 years, it would have said that. It says an elector and a resident for 5 years. Why didn't it have that 5 years language on both of them? The city, again, this whole thing revolves around the construction of the word "and." So I don't think it's mandatory, and I also don't think that it is John Q. Public's common reading of it. I think you could read it either way and be within your rights. That's why I'd like to focus on the second argument, which is the charter language is irrelevant in the sense that Mr. White meets the qualification, no matter how you read that section of the charter. Because it's 30 days, not 5 years, then you have to be an elector.
Okay, Mr. Depp,
Okay. Well, first of all, we're not asking to be taken off the ballot. We're saying he can't be on the ballot. There's a difference between being an elector, one who can vote, versus one who is a candidate. Just because you're an elector doesn't make you a candidate in the city of Youngstown, because in addition to that requirement of being an elector, you have to be an elector for 5 years. He fell short of that, and he would only become a candidate in February of 2026.
Mr. Myers, does the city have a right to mandate who has the qualifications and what qualifications there need to be for someone to be the mayor? Does a charter city have that right?
In a general sense, yes.
Okay.
And it has to be expressed in a clear, concise way.
And your argument, contrary to Mr. Depolito's argument, is that this, it clearly means that for you to be a candidate, you must be voting for 5 years and a resident for 5 years, if I'm understanding your argument
That's
correctly.
right.
Well, it doesn't even say voting. I think their position has to be registered to vote for 5 years, which again, I still think is an interpretation that can be read either way.
Okay.
I'm always for people's suffrage, but I'm always, people vote, in Youngstown voted on this charter. So I want to honor what I think they meant by this, and that's what I think we're being asked to determine is, what did the people of Youngstown mean when they voted on this charter amendment? And I think that the people, my interpretation is that whoever put this charter amendment meant to me, you better be voting for 5 years in the city, and you better live in the city for 5 years. Because then you have skin in the game. Otherwise, you could be living in the city for 20 years, never have voted, never participated, file a petition, and then be mayor. I don't think that that's what they meant by this provision. I think they meant they wanted someone who's involved in the election process and involved in voting and getting skin in the game. Because one thing I have no tolerance for, and I'll say it publicly, people have a constitutional right not to vote. But to me, with a son that serves, if you're not voting, Don't talk to me. Don't talk to me. It's as simple as that. People have spilled blood for your right to vote. There should be no reason why we're not getting every person who's eligible to vote in this country. It's ridiculous to me. So,
Mr. Beatrice, can I ask a question?
go ahead.
I think we've all agreed that there's no definition of an elector in the charter. So if you revert back to the definition of an elector under the different provisions of state law that I cited, the Ohio Constitution, the Ohio Supreme Court decisions, and state statutes, it doesn't require you to be registered to vote to be an elector.
I understand completely your argument. What I'm saying is, the people of the city of Youngstown voted on this charter amendment. You're asking us to interpret what we feel the people of the city of Youngstown were voting on. And I'm saying, just a plain reading of this, I know you want to sparse out elector from registered to vote. But I think what the people of Youngstown were voting on was, you better be voting in our city for 5 years, and you better live in our city for 5 years. That's how I'm interpreting this. I could be wrong, I'm oftentimes am wrong, but that's how I'm interpreting that charter provision. Go ahead, Mr.
In
Duncan.
the case that was originally cited by Mr. Myers, it was a case that had a similar provision of a 2-year requirement for someone to run for clerk of courts. And even though the case stands for other things, it accepted the fact that the charter city had the right to place an additional requirement on top of an elector. That 30-day requirement to become an elector in Ohio is fine, and we don't dispute that. But to run for office, we were requiring that you be around for a 5-year period. That's what this is all about. And that's what the word "and" is intended to mean, and the plain language of it, according to statute, means they have to go together.
From everything I know, and means you have to read them both in conjunction with one another. And I think what Mr. Myers wants us to do is sparse out the word elector and say, well, since he technically could be an elector and he wasn't for 5 years, therefore, I think that's not how I read that charter amendment, and that's not how I would apply that charter amendment to this. I think what the people of the city of Youngstown are saying, you want to be a candidate, you want to be the mayor, you better be participating and voting for 5 years, and you better live here for 5 years, and I could see people wanting that.
Mr. McCabe, can I ask you a question?
Sure.
Have past boards considered this issue?
We considered this 4 years ago in this same case, and,
Yeah, it was in our minutes from July 6, 2021. However, we didn't have to make that decision back then because he had voted in the May 2021 primary as a Democrat, so he couldn't run as an independent, so he wasn't allowed on the ballot.
correct, but we received an opinion from the Youngstown Law Department that's almost identical to this one.
Yes, that stated he would qualify in 2026, 5 years immediately preceding.
And certainly, everyone has a right, if they felt a charter provision was not constitutional, to take that to court and challenge it. And not challenge it at the time they run. If they felt that, that if he felt that this was gonna be an issue, he has a right to sue, to determine, have a court strike that, and he didn't, and now he's throwing this sort of onto us. And so now we have to make a decision based on what we have in front of us, where a court would have the benefit of briefing and oral arguments and everything else. We don't have the benefit of that. We have deadlines we have to make. And so I think that the charter amendment, as I read it, seems clear to me what the intention was. And to me means you gotta be both. Mr. Myers says, well, he was an elector, but he wasn't registered to vote. I think that requiring that you be a voter and that you live in the city for 5 years, I think, that's what I think that means. Denise, do you have anything?
I also think that if you're gonna say one is an elector, You can only become an elector means you have the right to vote. You can only become an elector if you register to vote. Therefore, I don't believe the interpretation of Mr. Myers is accurate. We disagree on that point.
Well, but with all due respect, Mr. Dubois, you haven't cited anything that contradicts or counters the provisions of the state constitution, the Ohio State statutes, and the Ohio Supreme Court decision that I cited that does distinguish between an elector and someone being registered.
It's not a conflict, we're saying it's an addition. It's an additional requirement that we are entitled to make as a charter city.
Mr. Myers, are you referring, and this comes from State Ex Rel Taylor versus Lucas County Board of Education, when you said Ohio Supreme Court case, are you talking about State Ex Rel Erling versus Bliss? Elector or qualified elector means a person having qualifications provided by law to entitle him to vote. Is that what you're referring to?
Different case, but that's the definition, yes.
Okay, that's the first case that defines an elector. Okay.
Yeah, having the qualifications is the age of 18, United States citizen, living in the city and the county that you want to run for or that you want to vote in. That's the qualifications of an elector. It doesn't say anything about being registered to vote. So, again,
Is it your contention that a city cannot prevent, well, double negative, I'm sorry, that a charter city does not have the right to impose further qualifications on a candidate for a particular office?
I think the
no,
answer
no, I'm
is
not saying that. I'm
yes.
saying that Mr. White meets those definitions because the definition of, by my definition and the Supreme Court's definition of an elector, he's been that for more than 5 years. Even if you take
Here's the
definition of
here's the issue stripped out. The city's position is, we want you to be voting for 5 years and live in the city for 5 years. Mr. Myers' position is, well, I was eligible to vote for 5 years, but I chose not to vote for 5 years, and I've been a resident for 5 years. That's the singular issue that we're being asked to decide. And if you look at the charter, which is right here,
Right, I see.
it seems to me pretty clear what they're intending by that.
I think Jason would like to add one thing.
Go ahead.
Okay, if I may add one thing. Revised Code Section 3503.01, and forgive me for reading. Every citizen of the United States who is of age 18 years or over and who has been resident of the state 30 days immediately preceding the election at which the citizen offers to vote is a resident of the county and precinct in which the citizen offers to vote and has been registered to vote for 30 days, has the qualifications of an elector, and may vote at all elections in the precinct in which the citizen resides. So that 30 days has been expanded to 5 years in the home rule authority of the city.
Yeah, that's how I'm reading it.
Yep.
That's how I'm looking that the people in Youngstown meant. I think that, maybe I'm wrong, but I think the people in Youngstown don't sit around here for 20 years and don't vote, and then want to run for office and vote. You got to participate in voting and having a vote and participating in, using your voice to participate in the democracy. You can't sit around for 20 years and say, hey, I don't like what's going on. I'm going to now run for mayor, and then say, well, I was able to vote, but I didn't register to vote, or I'm technically an elector, but I wasn't an elector for 5 years, and you should give me a pass on that. I don't think that's what the people of Youngstown intended, and so it seems pretty clear to me. You have to say something else?
Yeah,
No, I know.
What?
So has he been a resident for 5 years?
yes.
Because I know there was a question back in 2021 as well.
I don't think that's been in any dispute before the board, and I don't think, I mean, I could have him testify if you want.
No.
It's not been an issue.
I do know that Mr. White has a residence or a home of a property in Trumbull County. And it's been during a period of time, so I don't know where he lives. We didn't pursue that.
But I agree with Chairman here, the mayor shall be an elector and a resident of the city of 5 years immediately preceding the memorial race and not less than 30 years of age, which I think you qualify because you're not less than 30.
Although we
And,
might have to card you.
But as a, not an attorney, reading that, to me, I would believe that the elector means someone that can vote, not somebody that, your definition of an elector is anybody that has lived anywhere, that's over 18.
For
Well,
30
yeah,
days.
but you, for 30 days, but you can't show up in November if you didn't register to vote. You can show up, but it's not gonna count.
But what I'm saying is, for the sake of argument, I'll concede the 5 years. He's been an elector for 5 years. If the definition of an elector is that he's otherwise qualified to vote where he lives.
Okay, so you're complaining it shouldn't be 5 years immediately preceding then? Because that's what this charter says. And that would be next year in 2026.
No, he's lived where he's lived for 5 years, and he's been otherwise qualified for more than 5 years. He's been over 18 or over 30, whatever age you wanna define it as. He's lived
Well,
in the city,
then my
in the
question
county,
was, why did he register at all if he wanted to run for mayor?
because he was told last time that that would be an issue. Now, the other issue of his having voted for a party in a Democratic ballot, that negated the argument about that we're here on today. He never got voted on, but it was raised as an issue, so he registered to vote. But my
Let me
assumption
ask
is he didn't really have to in terms of the legal definitions of an elector, but that's why we're here.
If he knew this was gonna be an issue, why not file suit and have a court determine that that's unconstitutional? Because you're asking us to overturn an election of the people of the city of Youngstown. You're asking us to say, ignore what the people in the city of Youngstown have said in this charter amendment, and you overrule this on constitutional grounds. I think that's a bridge too far for me. I think I'm just giving it its plain reading and what I think the people meant, and that he certainly had an opportunity to challenge that before this board, and if we're wrong, he has an opportunity to challenge it now.
Well, the answer to your question as to why he didn't sue before is because he wouldn't have had standing. Courts don't accept preemptive or advisory opinions. He is only able to sue even for a definition on a constitutional issue or a charter issue when there's an actual issue of controversy before the court. To just have a citizen say, I'm thinking of running and I want to get an advisory opinion on whether this is legal, the courts would throw that out.
I don't think it's an advisory opinion. I think he could say, I'm planning on running, this is a provision, it's gonna prohibit me from running. I think you had plenty of opportunities to challenge this.
It would be deemed premature.
Well, it won't be deemed premature now.
No, it won't. I'm just answering your question, why he didn't sue earlier. He really couldn't, because there's no issue before the court, because there's no issue before the board.
Does anyone else want to make any other comments or concerns? All right, I will take a motion as to whether or not we should accept John White's candidacy for mayor. Is there a motion?
I'll make a motion to disqualify the petitions of Mr. John White for mayor of the city of Youngstown based on section 4 of the Youngstown City Charter.
There's a motion made by Sandra Barger, Vice Chairwoman Sandra Barger, to not allow Mr. White to be a candidate based on section 4. Is there a second?
I second.
Seconded by Denise Bayer. Is there any comments, questions, or concerns more than what we've already had? Hearing none, would the director call the roll, please?
Vice Chairman Barger.
Yes.
Chairman Beatrice.
Yes.
Attorney Robinson.
Yes.
Attorney Bayer.
Yes.
Okay. Moving next to our agenda, the director's report. We have anything?
Do you have something? Any websites?
Well, just thought you guys might want to see the front page. This is our current.
We're getting there, huh? We got a front page.
Oh, we got a front page.
Yeah. This is the current.
Now, this is the website, not the app.
This is the
Correct.
first page, yeah, it's the website, and this is what the front facing page will look like, and it's quite a bit different than our current. I just thought you might get a little excited. Got lots more to do yet. Isn't that pretty? Nice and organized. Oh, we go.
All right.
Just share.
Unfinished business. I have something on unfinished business. I don't know, rumor, conjecture, whatever, that county commissioners have found a home for us. We are not obligated to take that home if it does not fulfill our legal requirements. I want this board to be aware that I went to the commissioners' meeting. I gave them the specific instructions from the Secretary of State of what we need for a board of elections. If the building they've decided they're gonna foist upon us does not meet those requirements, I'm not going to vote to move it because we all took an oath to uphold those standards. And I've given them the standards. They're aware of the standards. I sent those standards to the prosecuting attorney and said, these are the standards that we must meet for a building. So we'll have to see. I heard they have a building, they haven't have a building, but we're under no obligation to just sit there and take it because we are an independent board. We are by law created independently to make independent decisions. We do not have to take a building they get for us. And we can, we have other legal remedies available to us. So that's the only thing I have under unfinished business. Anything under new business? Anything for the good of the order of public comments? The next regularly scheduled meeting of the Mahoney County Board of Elections will be Tuesday, August 5th, 2025 at 4 p.m. in the boardroom of the Mahoney County Board of Elections offices, 345 Oakville Avenue, Youngstown, Ohio, 44502. And thank you to my wonderful vice chairwoman who keeps me in line saying, I no longer have to ask for a motion to adjourn. I can just adjourn, right? This meeting is now adjourned.